Good morning. I am Dr. Ritu Gupta, Faculty, National Law University, Delhi. In today's module, we'll discuss investigation of companies, its need and procedure. Let us have an overview of this module. This module focuses on the importance of investigations relating to the affairs of the company and the applicable procedure. The new Companies Act, that is Companies Act 2013, provides for inspection, inquiry and investigation of companies, which is provided in Chapter 14 from sections 206 to 229. And these sections 206 to 209 empower the registrar to call for information, inspect the books and conduct inquiries. Such powers may be exercised if any scrutiny of any document filed by a company or any other information he feels that any other explanation or information is required. Section 210, that is section 210, provides that the central government may have and may conduct investigation into the affairs of the company, and sections 211 to 216 provide for the establishment of a SFIO, that is Serious Fraud Investigation Officer, and investigation by inspector when appointed. The procedure of such investigations has been stated under section 217, and the further sections in this particular chapter, they provide for related steps for investigation and penalty for furnishing false statement, mutilation and destruction of documents by the erring companies. The companies, they are committing any type of fraud. The objectives. The objectives of this module is to provide preliminary knowledge about the investigation of the companies to the students. Further, the objectives are to apprise the students of the need and importance of the investigation of the companies and to make students understand the procedure of investigation as prescribed under the Companies Acts. In the last few decades, there have been a radical shift in the perception towards the business generally and incorporated enterprises specifically. If we talk about a case in National Textile Workers Union, the Supreme Court of India observed that the company is now no longer a mere profit-making enterprise, but it has assumed the role of a social institution to discharge its social responsibilities for accomplishing the socio-economic objectives of a welfare state as enshrined in Part 4 of the Constitution of India, that provides for the directive principles of the state policy. Further, to keep an effective control and check over the functioning of the companies, the Companies Act 2013 provides for administrative machinery as well as the procedure for inspection, inquiry and investigation of the companies. This act imposes a duty upon the directors and officers of any company to produce books and papers and provide information demanded by the registrar. Disobedience on the part of the directors make them liable for imprisonment as well as fine. The registrar or the inspector may order for such and seizure of books and papers if they have some ground to believe. So those grounds should be reasonable. The central government is authorized to issue orders for such investigations. The Act provides for establishment of SFIO, as I told in the overview, to investigate this type of frauds. Now let us talk about what is the need for investigations of companies. Since the shareholders themselves are unable to supervise and ensure efficient functioning of the companies, the organized supervisors by government agencies assume significant role. It's only efficient and smooth functioning of the corporate that can ensure an adequate return on capital invested by the shareholders. And this need was explained by the Supreme Court in Barium Chemicals Limited case. In Barium Chemicals Limited, the Supreme Court has observed the elementary philosophy of the Companies Act is to trust the shareholders for ensuring efficient performance, but for reasons more than one, the shareholder, they have already receded to the background. Firstly, he is an investor who for the most part does not wish to be bothered except for dividends. Secondly, due to great diffusion of stock, shareholders become indifferent to voting and controlling. And thirdly, the shareholders are ill-equipped to challenge the wisdom and experts of officers. Fourthly, for shareholders have the means or ability to act against the management. If we can take a quote from Freund. He says, the reality of control can only be found in the action of public opinion and in the organized supervision exercised by government agencies. Hence, this is the importance of investigation. That is why we are doing this module, and that is why the Companies Act has provided for all these provisions. Thus, the provisions for investigations, they help prevent corporate abuses as well as wrongs and ensure efficient functioning of the corporate managements. If we compare inspection and investigation, first I'll talk about inspection. The registrar is empowered to carry out inspection of the books of accounts and other documents of the company, where on a scrutiny of any document filed by a company or on any information received by him, the registrar is of the opinion that any further information or explanation or any further documents relating to the company is necessary, he may by a written order require the company to furnish in writing such information. This has been provided in subsection 1 of section 206. If the information provided by the company is inadequate or, in registrar's opinion, unsatisfactory state of affairs exists in the company or does not disclose a full and fair statement of the information required, he may again call on the company to produce such books or papers. The provision is there in subsection 3 of section 206, and after fulfilling this procedure, the registrar may carry such inquiry as he deems fit. It's there, 206 subsection 4. The central government may authorize any statutory authority to carry out the inspection of the books of accounts of a company or class of companies. 206 subsection 5 talks about it. For carrying out on inspection or inquiry, the registrar or inspector shall have powers of a civil court in relation to the matters as has been prescribed under subsection 3 or section 207. The registrar or inspector shall submit a report to the central government and recommend, if necessary, further investigation is required into the affairs of the company. Further, the registrar or inspector may enter and search the place or places and seize such books and papers if he has reasonable grounds to believe that such papers as mentioned are likely to be destroyed, mutilated, altered, falsified, or somehow they have secretly deposited somewhere. No company or member can ask for a copy of inspection report. The expenses of inspections are borne either by the government, and these are not recoverable by the company. Section 225 provides for it. And if we compare inspection and investigation, so let us talk about the procedure of investigation first. On receiving the report of the registrar or inspector under section 208 or on intimation of a special resolution passed by a company or in public interest, the central government may order an investigation where necessary into the affairs of a company. The central government may appoint one or more persons as inspectors to investigate into the affairs of the company, and no firm, body corporate or association shall be appointed as inspector. Further, the central government shall establish an office which would be termed as I told you in the introduction, SFIO, that is Serious Fraud Investigation Office, to investigate frauds relating to companies. It is a multidisciplinary organization consisting of experts from various fields. If we name banking, law, corporate affairs, they may be experts in taxation or information technologies, and further the details are provided. The directors of SFIO may designate such number of inspectors as he may consider necessary to investigate into the affairs of the company. Where any case has been assigned to SFIO, no further investigation order of agency of either central or state government can investigate the same case. The officer designated shall have the powers of an inspector as has been provided under section 217. SFIO shall conduct the investigation in the matter and follow the procedure as per the provisions, and he is going to submit his report to the central government within the specified time period. The central government may demand an interim report of the investigation. The director, additional director or assistant director of SFIO may arrest any person who he believes is guilty of an offence punishable under the section. Such person arrested shall within 24 hours be taken to a judicial magistrate or a metropolitan magistrate who has got the jurisdiction. A copy of the investigation report may be obtained by any person concerned by making an application in this regard to the court. Section 212, subsection 3 can be referred for this. The expenses in the first instance shall be defrayed by the central government but may be reimbursed partially or fully by the persons as prescribed under section 225. Let us talk about the rights of bail of persons charged and arrested guilty persons. Section 212 subsection 6 to 10 provide for it. They deal with the procedural aspect. The offences specified under various provisions of the Act that attract punishment for fraud under section 447 are to be cognizable offences. The persons accused of any such offence shall not be released on bail or on his own bond unless the public prosecutor have been given an opportunity to oppose the application for such release. The court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence. However, the following may be released on bail if the special court so directs. If the situation is that the person is below 16 years of age, it's a woman, or somebody who is sick, or somebody who is frail or infirm. The special court is not to take cognizance of any offence except upon a complaint in writing made by the director or by the SFIO investigating officer or any other officer of the central government authorized by a general or special order in writing. These limitations of section 212 subsection 6 are in addition to the limitation as have been provided under the Criminal Procedure Code 1973. Let us now discuss the powers of the central government. The central government may appoint persons having expertise in the field of investigations, cyber forensics, they may be persons from financial accounting, management accounting, cost accounting and any other field as may be necessary for the efficient discharge of SFIO functions under the Act. Rule 3 of the Companies Act, Inspection, Investigation and Inquiry Rules 2014 provides for it. The central government, where it deems appropriate, may assign the investigation into the affairs of any erring company as per the provisions of section 212 to the SFIO. Further, if the central government so directs, the SFIO shall submit an interim report or investigation report on completion of the investigation to the central government. On receipt of the investigation report, the central government may, after examination of the report and after taking such legal advice as it may think fit, direct SIFO to initiate prosecution against the company and its officer or employees who or have been in employment of the company or any other person directly or indirectly connected with the affairs of the company. Where the central government orders such investigation, it may require the applicant to give such security not exceeding rupees 25,000 for payment of costs and expenses of investigation as per the criteria which has been mentioned in the Rule 5 of the Companies Inspection Investigation Rules, as I just talked 2014 rules. Now talk about investigation by the tribunal, and section 213 of the New Companies Act provide for it. And it says that the following other cases, the tribunal may order investigation into company's affair where an application has been made by a member, not less than 100 members or members holding 1/10 of the total voting power in the case of a company having share capital not less than 1/5 of the person on the company's register of members in the case of a company if the company is without share capital. And the said application should be supported by such evidence as may be necessary for the purpose of showing that the applicants have a good reason for seeking an order. And if that application is made by any other person or otherwise if the circumstances suggest that the business of the company is being conducted with intent to defraud its creditors, members or any other person or otherwise for fraudulent or unlawful purposes or in a manner oppressive to any of its members, or that the company was formed for any fraudulent or unlawful purpose. Persons concerned in the formation of the company or management of the affairs have been guilty of fraud, misfeasance and other misconduct towards the company or towards any of its members, or the members of the company have not been given all the information about its affairs which they might reasonably expect, including information relating to calculation of the commission payable to managing or other directors or to the manager of the company. Reasonable opportunity of being heard must be provided to the concerned parties. The central government shall appoint one or more persons or inspectors to investigate into the affairs of the company. Such inspectors shall submit their report to the government. The defaulting persons are liable to be punished for fraud, and that has been provided under section 447. Let us talk about investigation of ownership of the company. Sometimes what happens in public interest, it becomes necessary for the central government to know the true persons who are financially interested in the success or failure of a company and control its policy or materially influence the policy. So, in view of these mentioned reasons, section 216 of the Act provides that the central government shall appoint one or more inspectors to investigate and submit report on matters pertaining to the company and its memberships. Moreover, the central government is bound to appoint inspectors if the tribunal in the course of any proceeding before it directs that the affairs of the company ought to be investigated as regards its memberships and other purposes. The central government may define the scope of the investigation, whether in respect to the matters or the period which it should extend, and particularly may limit the investigation to matters connected with particular shares or debentures. The powers of inspectors shall extend to the investigation of any circumstances suggesting the existence of any arrangement or understanding which, though not legally binding, may be observed, may be in present or past, or is likely to be observed in future or in practice, and which is relevant for the purpose of investigation. Now we talk about the procedure and power of inspectors. Section 217 of the Act provides for it, which states that it is a duty of all officers, employees and agents, past and present, including those of any other corporate whose affairs are under investigation. Section 219 states to preserve and to produce to the inspector all books and papers relating to the company and otherwise are reasonably able to give. For investigation, the inspector has the power of a civil court, and a reasonable assistance shall be provided to him by the officer of the central or state government or police or any other state authority. Notes of the examinations are to be taken in writing, read over to the person, signed by him, and then they become evidence against him. Failure to furnish requisite information or procedure, books and papers to appear before the inspector in person whenever required, or to sign notes makes the defaulter punishable. That punishment can be imprisonment for a term extending to 6 months and fine of not less than rupees 25,000 and that may extend up to rupees 1 lakh and rupees 2,000 for every day during which the default continues. The central government may enter into agreement with the government of a foreign state for reciprocal arrangements to assist in any inspection, inquiry or investigation. Further, we have section 218 which provides which protects employees from any action being taken against them during the course of investigation without approval of the tribunal. Section 219 enables the inspectors to conduct investigation into the affairs of the related companies. Further, section 220 empowers the inspectors to conduct searches and seizures as if he had the right to do so under the provisions of the Criminal Procedure Code 1973. The tribunal is empowered to order for freezing the assets of the company during inquiry and investigation under the prescribed circumstances. Further, it imposes restrictions upon securities if appears to be necessary, which are needed for finding the real facts. Section 223 provides that the inspector may submit his interim reports and final reports on the conclusion of the investigation in the central government. A copy of the report can be obtained by making an application to the central government, and the report has to be authenticated by the seal of the company whose affairs have been investigated, or by a certificate of the public officer having custody of the report as per section 76, if we can recall Evidence Act 1872, and this report is admissible in any legal proceedings then as evidence to its contents. This section shall not apply to the report of SFIO and section 212. Now we talk about the action which is to be taken in pursuance of the report. Section 224 of the Act provides, and it states, if from the report it appears that any person has been guilty of an offence for which he is criminally liable, the central government may prosecute him for the offence. The company and its employees shall be duty bound to provide the necessary help in connection with the prosecution. If the report shows that it would be expedient to wind up the company, the central government may file a petition for winding up of on the following grounds can be stated, that is just and equitable grounds, or if an application for prevention of oppression and mismanagement under section 241, or if both these factors are present. If it appears to the central government from the report that the proceedings ought to be brought in public interest by the company or any body corporate whose affairs have been investigated for recovery of damages in respect of fraud, misfeasance or other misconduct in the promotion, formation or management of the company, or for recovery of any property of such company, then the central government may itself bring proceedings for winding up in the name of company, for which the company has to indemnify the government for the costs. Now we discuss the disgorgement of benefits obtained by the directors. Section 224 subsection 5 states, where the report states that a fraud has taken place in a company and due to such fraud any director, key managerial personnel, other officer of the company or any other person or entity has taken undue advantage or benefit in any form whatsoever, the central government may file an application to the tribunal for appropriate order for disgorgement of such benefit and also for holding the person concerned liable personally without any limitation or liability. Section 225 of the Act provides for the expenses of the investigation, which are to be borne by the central government at the initial stage, but the government can seek reimbursement from any person who has been convicted or prosecuted or called upon to pay damages or restore the property of the company in whose name the proceedings have been brought, or person dealt with in the report, or applicants for investigation where the inspector was appointed under section 213. Further, section 226 provides for voluntary winding up of the company, which should not stop somehow investigation. An investigation can be initiated and it is not to be stopped only because an application has been made under section 241 or the company has passed a special resolution for voluntary winding up or any other proceeding for the winding up of the company is pending before the tribunal. The inspector has to inform the tribunal of the pendency of the investigation. The tribunal may pass such order as it deems fit. Legal advisors and bankers not to disclose the information. This has been stated under section 227 that those legal advisor or bankers, they should not disclose any privileged communication or information relating to the affairs of the customers of the bank. And section 228 provides for investigation of foreign companies with effect from 1st April 2014. The provisions mentioned herein shall apply mutatis mutandis to inspection, inquiry or investigation in relation to the foreign companies. Penalty for furnishing false statement, mutilation or destruction of documents is provided under section 229, which provides that any person who is required to provide an explanation during the course of inspection, inquiry or investigation destroys, mutilates or falsifies or conceals or tampers or unauthorizedly removes documents related to property or affairs of the company, or makes a false entry in any document concerning the company or body corporate, or furnishes false information, shall be punishable for fraud as provided under section 447. In this module, we have learnt about the need and importance of investigation of companies. We have understood the legal framework of investigations pertaining to the affairs of the companies, and we have tried to find out the prescribed procedure for the same under the New Companies Act 2013. Thank you.